Good afternoon, ladies and gentlemen, members of the board. My name is Alexandra Edmonds, a special counsel at Jones & Jones Law Firm, specialising in employment and workplace relations as a solicitor. Firstly, I would like to thank the board, members and the company iLearn for giving me the opportunity to present and provide you with advice in relation to your company and, importantly, the technological secrets and trade within. I am here today to discuss the duties your employees owe to you, both whilst employed and post-employment, namely loyalty, confidentiality, and privacy. I will also provide advice on the measures that can be taken to protect the company's intellectual property from misuse or theft from key software developers and sales staff within your company. I understand the important concern of confidentiality and how it can potentially impact your company in a great way. Not only do you need to be able to trust your employees with sensitive information, but you also need to be aware of how you can control and protect this information from being leaked into public and potential competitors. By ensuring your employees are made aware of what duties they owe to the company during their employment, it helps make a solid foundation and sets clear boundaries for your employees to adhere to. Even after employment relationship ends, an employee may remain bound not to use or disclose confidential information they have obtained in the course of their employment. Legal actions for breach of confidence most commonly relate to commercial, technical information and ownership of intellectual property rights held by private individuals or companies like yourself. This is particularly relevant where a job principally involves research and invention. In such a sensitive area, it is of the utmost importance that employees and past employees practice and adhere to their duties of loyalty, confidentiality, and privacy to avoid misuse or theft of the software development. Especially so where an employee is in a special position of trust and confidence. In such a position, a duty arises from the contract of employment and fiduciary duties. In the context of confidential information, the duty of fidelity requires that an employee must not use information obtained in the course of his or her employment to the detriment of the employer. If an employee behaves in a way that constitutes as undermining their existing or former business, it will contravene the duties of confidentiality, loyalty, and fidelity. The equitable action for breach of confidence may be used to restrict the disclosure of information in certain circumstances. This duty is based on the equitable doctrine of breach of confidence, as well as being a condition implied into contract employments where the employee handles confidential information or is privy to secret processes. The equitable action for breach of confidence may be used to restrict the disclosure of information in certain circumstances. The principle is that the court will restrain the publication of confidential information that was improperly obtained or of information imparted in confidence which ought not to be divulged. Whether written to the contract or not, every employee has a duty to serve their employer faithfully. Therefore, it is clear that while employees are held to these standards, it is also important to consider implementing terms and conditions of loyalty, discretion, and trust into employment contracts if it isn't already. Some of the acts that are considered as breaching a duty of fidelity when an employee is in the process of preparing to establish a future business include soliciting the employer's clients to switch the new business, recruiting other staff presently working for your business, deliberately removing, copying, or memorizing any of the employer's valuable information, assisting in rival business that the employee intends to join. There is a fine line also as to what actions are actually lawful and what actions are not. So that's something to consider if an employee is looking to set up a business as a competitor. It has been noted that the courts do come down quite hard on anyone who is caught copying or emailing documents or files, or furthermore, seeking to redirect work elsewhere while still employed and under the duty of fidelity to the employer. Also, if an employee has multiple jobs, it's important to understand that the breach of the duty of fidelity can arise depending on the nature of the other jobs. But generally speaking, if an employee works for someone else during a time that they are contracted to work for you, that they would again be breaching this duty if no permission to do so has been granted by you. This also occurs if the second job is prioritized and the workload is too much so that it makes the employee too tired to even commit and properly perform the work at your business. Essentially, employers have the power to give directions and orders to their employees and expect them to obey them, and this is an important feature of an employment contract. It is also lawful for an employer to give directions to employees to not make public comments about an employer's business. Generally, this is more applicable to senior employees. As your business is vulnerable to misuse or leakage of your intellectual property since it involves researching and developing software, you don't want competitors to gain access, and it is therefore necessary that we discuss the ways in which your property can be protected. You are able to protect your company's intellectual property against misuse or theft by key software developments and sales, both during employment and post-employment with these measures below. Firstly, it is recommended that you introduce policies to all your employees which deal with copyright, patents, new and distinctive designs for commercial products, and trademarks, including names and logos and labels, etc. Further, I would also recommend that additional conditions be applied into employment contracts as I mentioned above, particularly where employees are privy to private and confidential information. The duty known as the equitable doctrine of breach of confidence, which was briefly discussed earlier, provides that an employee is obliged to not disclose any confidential information to third parties without your consent. If an employee was found to breach such a duty, you as an employer can seek an injunction, or you may seek damages or compensation for any loss that you may have suffered as a result of this breach. There is a limit to this duty, however. If the information is already widely known within the outside of the business, then this could not be a breach of confidence and will also be acceptable for an employee to freely use as any information that they can remember after ceasing employment. So anything that is general know-how that they can easily recall on may not be classed as a breach. The Corporations Act also prohibits an employee of senior levels from using any confidential information to gain an advantage or undermine the business. Lastly, as stated earlier, at the end of an employment contract, an employee still has a duty of confidence to keep your information confidential. Employees have a duty to be loyal, adhere to confidentiality and privacy policies, and any breach of these should attract a penalty. I would advise you to insert restraint trade clauses or an agreement, as I mentioned above, that restricts employees that are privy to sensitive information from working with or for competitors, either during employment or after employment with your company. I would also advise that these provisions are inserted into the contracts prior to employment, as extra consideration would most likely need to be offered when inserting into current employee contracts. Thank you for listening, and I do hope this information and advice helps your company in the future.